Senator will come to order. First order of business, I'll recognize the senator from the first.
Mr. President, I move that the Senate insist on its substitute to House Bill 684.
The senator has moved that the Senate insist on its substitute to House Bill 684. Is there any objection? Hearing none. So moved. The senator has moved that the Senate insist on this to House Bill 684. All those in favor of the motion will say aye. All those opposed will say no. All those in favor of the motion shall rise, stand, and be counted. Clearly, we have it. We have a majority. It passes. Reverse. The ayes have it. Mr. Secretary, would you read House Bill 121?
House Bill 121 by Representative Administration of the 104th and others, the bill we title enactment, Chapter 12, Title 53 of the OCJ, relating to trusts with the change provisions relating to minor unborn beneficiaries, change provisions relating to non-judicial settlement agreements, the modification and termination of non-charitable trusts, and distribution to another trust and for other purposes. Mr. President, that concludes the order.
Call upon the senator from the 23rd to present the bill.
Thank you, Mr. President and colleagues. This is a bill that modernizes Georgia's trust law. It's the 8 years of effort of the fiduciary section of the State Bar of Georgia. It provides non-judicial settlement of matters relating to trust with the consent of all parties. It allows for identifying who can represent minors and unknown beneficiaries, such as unborn persons. It also allows for statutory mechanisms for modifying irrevocable trusts. This will allow for efficient administration of the trust. It also provides a statutory mechanism for distribution from a trustee of an existing trust to a new or amended trust, a process that is known as decanting. It also provides for appointment of a trust director. This is someone who can oversee a trustee to make sure trustee is carrying out all his duties and responsibilities. It also deems the transfer of a property in which the trust is named as grantee is deemed to be a transfer to the trustee in his capacity as trustee. It also allows for a higher dollar amount on trusts that can be terminated due to the cost of administration from $50,000 to $100,000. Clarifies creditor rights where a trustee is given unfettered discretion but guidelines as to distributions. And finally, it increases the duration of trust from 90 years max to 360 years. With that, I'll yield for questions.
Senator, there are no questions.
Urge your support for HB 121. Thank you.
Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee?
I'd like to excuse the senator from the 29th for business outside the Capitol.
Is there objection to excusing the senator from the 29th? Hearing none, the senator is excused.
Thank you.
Thank you. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is now ordered. Shall this bill pass? The question is on the passage of the bill. All those in favor of the bill vote yea. Those opposed vote nay. Mr. Secretary, if you unlock the machines. On the passage of the bill, the yeas are 42, the nays are 1. This bill, having received the requisite constitutional majority, is therefore adopted. Mr. Secretary, read House Bill 927.
House Bill 927 by Representative Nimmer of the 178th and others, a bill to be titled enactment in Part 1 of Article 3 of Chapter 11, Title 15 of the OCGA relating general provisions relative to dependency proceedings, so as it requires certain information be provided to a caregiver, foster parent, pre-adoptive parent, or relative by DFCS upon a placement of a child and for other purposes. Mr. President, the Senate Committee on Health and Human Services offers the following substitute to House Bill 927, a bill to be titled enactment Article 2 of Chapter 34 of Title 43 of the OCGA relating to medical practice, so as to revise provisions related to the delegation of certain medical acts to advanced practice nurse, to revise definitions, to provide for changes to radiographic imaging tests, to provide for changes to the ratio of a delegating physician to advanced practice registered nurses, to provide for related matters, and for other purposes. Mr. President, that concludes the order.
Call upon the Madam Chair of the Health and Human Services Committee, Senator from the 45th, to present the bill.
Thank you, Mr. President, members of the Senate. I bring before you House Bill 927, which is a bill that is relevant to the Nurse Protocol Agreement. We have already voted on this bill here in the Senate. We voted on it first in the Senate Health and Human Services Committee. It passed out of committee 10-0. And it passed on the Senate floor, I don't know what day, but it passed on the Senate floor as Senate Bill 351, 41-10. So you probably recall that this is the bill that was basically watered down and changes the Nurse Protocol Agreement from 4 to 8. And it also allows advanced practice registered nurses to order radiographic images. So with that, Mr. President, I'll be glad to answer any questions if someone doesn't remember exactly how they voted or what they voted on.
There are no, I beg your pardon, Senator, there are questions. Senator from the 46th.
Will the senator yield?
Yes, sir.
How does this bill differ from the version that passed out of the Senate earlier this session?
It doesn't differ.
The same?
It's the same exact language.
Okay. Thank you, Senator.
Senator from the 31st, you're recognized for a question.
Thank you, Mr. President. Does the senator yield?
Yes.
Is this an expansion of scope bill?
No, not, well, is it an expansion of scope of practice for advanced practice registered nurses? It increases the number from 4 to 8, and it also allows them currently in current law, they can order radiographic images in life-threatening situations. This will give them the ability to do so at any time.
So it is an expansion of scope bill then?
Hopefully it is, because we have a real problem with workforce development in the healthcare industry with not enough professionals being able to do enough work. These professionals, APRNs, are taught in school to do even more than what this watered-down version is in other states. We're the only state in the nation that doesn't allow this. And, of course, it's controlled by other scope of practice special interest groups. Thank you.
Senator from the 36th, recognized for a question.
Thank you, Mr. President. Senator,
Yes, ma'am.
Senator, you may have answered my question really after my light went on and you were addressing another senator's question, but I don't think we can underscore enough the fact that this very modest piece of legislation, which allows these advanced practice nurse practitioners to employ imaging, is virtually across the country something that is done routinely on a daily basis by advanced practice nurses. Isn't that true?
That's exactly right. And as you and I know, because we've worked on so many women's issues, unfortunately, nurses in the nursing profession is held back. And it's my feeling, and probably your feeling, that they're held back because they are of the gender of being female. And they have been dominated by other male-dominated professions. And you're exactly right. We are the only state in the nation that doesn't allow this.
As you say, after full review in the Health and Human Services Committee, there was no opposition within our ranks. We were a unanimous vote
Yes,
for this modest step.
It's exactly right. And we do have physicians on the Health and Human Services Committee. The vote was 10-0, and they agreed in committee.
Thank you.
Senator, you have one additional question. Senator from the 31st, you're recognized.
Thank you, Mr. President. Senator, I thought I heard you say that we need this because nurses were female and that they were treated differently than their male counterparts. Did I misunderstand you on that?
That must have been those male ears listening to what I said, because that's not exactly what I said.
Could you restate your comment?
I was saying that the
senator?
senator from the 36th and I have worked on many women-dominated issues in the past in trying to get equality and fairness and parity for women. And unfortunately, nurses, like teachers, are a female-dominated profession, and they have historically been held back. And unfortunately, that's probably one of the reasons why the advanced practice registered nurses have been held back in the state of Georgia.
Thank you. That's what I thought you said.
Senator from the 2nd, you're recognized for a question.
Lady Noel, do you yield?
Yes.
Is this substitute in the same code section as the original bill?
This is a substitute to House Bill 927 and in committee. If you're asking about germaneness about this, that bill was stripped out. So yes, it is. It's completely about APRNs in this particular bill. So I think it's very much germane. And it was done through the committee process and done correctly.
Senator from the 40th, you're recognized for a question.
Does the lady yield?
Yes, sir.
Isn't it true at the end of the day what this means is, particularly in areas where we have no physicians, that the nurse can order an MRI and a CAT scan, and before anything would happen, have the results of that CAT scan, which would be read by a radiologist, I believe, then they would then be treated, and we may be able to save some lives by doing this?
You're exactly right, and I appreciate that.
Thank you, Madam Chair.
Thank you very much, and I yield and I ask for your favorable consideration the substitute to House Bill 927.
Thank you, Senator. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. All those in favor? Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any questions? The chair hears none. The main question is now ordered. Shall the bill pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machines. On the passage of the bill, the yeas are 34, the nays are 12. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read House Bill 927. Beg your pardon, 899.
House Bill 899 by Representative Lauricia of the 169th and others. The bill will be titled enacted in Chapter 10 of Title 13 and Chapter 91 of Title 36 of the OCGA relating to contracts for public works and public works bidding, respectively, so as to change the limitation on disqualification of bidders to prohibit the disqualification of bidders based upon lack of previous experience with the delivery method and for other purposes. Mr. President, that concludes the order.
Call upon a senator from the 30th to present the bill.
Thank you, Mr. President. Fellow members of the Senate, all this bill does, unless you want me to talk for an hour about the differences in delivery methods across the state, it just says you cannot be automatically disqualified from bidding on or proposing for a specific delivery method just because you've never done that delivery method before. Subject to your questions.
There are no questions, Senator.
I ask for your favorable consideration. I yield the well. Thank you.
You had us said hello. Does any other senator wish to speak for or against the bill, or is objection to agree in the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is now agreed to. Shall the main question now be put? Are there any other questions? The chair hears none. The main question is now ordered. Shall the bill pass? The question is on the passage of the bill. All those in favor of the bill vote yea. Those opposed vote nay. Mr. Secretary, if you'll unlock the machines. On the passage of the bill, the yeas are 42, the nays are 1. This bill, having received the constitutional majority, is therefore adopted. Mr. Secretary, if you'll read House Bill 904.
House Bill 904 by Representative Hanson, the 80th, and others. The bill will be titled enacted in Code Section 51325 of the OCGA relating to certain liability, not limited, so as to clarify provisions relating to the effect of an owner of land charging an admission price or fee and for other purposes. Mr. President, Senate Committee on Agriculture and Consumer Affairs offers the following substitute to House Bill 904. A bill will be titled enacted in Code Section 51325 of the OCGA relating to certain liability, not limited, so as to clarify provisions relating to the effect of an owner of land charging an admission price or fee and for other purposes. Mr. President, that concludes the order.
Recognize the senator from the 53rd for an announcement.
Hey, it's not an announcement. Just want to recognize some folks that are here with us today along the side of the wall. As you know, Georgia has 8 sole commissioners here in our great state, and no other place in the nation do they have them. So we have 5 of our 8 sole commissioners here. If you'd raise your hand and give them, or 6 of our 8 sole commissioners here, give them a hand. A lot of power right there.
Nothing worse than a commissioner with no soul. Thank you, Mr. Senator from the 53rd. We'd like to call upon the senator from the 19th to present the bill.
Thank you, Mr. President. Members of the Senate, I present to you House Bill 904. It's almost identical language to Senate Bill 431 that we passed out of this chamber 43-4 earlier this year. I'd ask your favorable consideration once again. What it does clarify is that as long as no one pays to be on property in a certain day, recreational property, that recreational property immunity still applies to that act. Thank you, Mr. President. I'll yield the well if there are no questions. I do believe there was an amendment, Mr. President, but I have not seen that amendment yet.
Senator, approach, please.
Okay.
Read the amendment.
Amendment 1 by Senator Miller of the 49th offers the following amendment. Amend the Senate Committee on Agriculture and Consumer Affairs substitute to House Bill 904 by deleting lines 9 and 10, inserting in lieu thereof the following. 2, for injury suffered in any case on a portion of land on a date when the owner of such land charges any person who lawfully enters or goes on such portion designated for. Mr. President, that concludes the order.
Senator from the 19th, describe the amendment.
Thank you, Mr. President. This amendment just tries to clear up some of the language in Section 2. I don't think it substantively changes any of the law, but it does read a little bit clearer and hopefully will help avoid judicial decisions that would need to be made in the future. If there is no objection, Mr. President, I yield the well.
There are no questions.
Thank you.
Thank you, Senator. Senator from the 26th.
I had a question for him. Senator,
Yes, sir.
if I own land and I charge you $1 to fish in my pond and something happened to you, then I'm responsible.
I think is that a question?
Yes, I'm asking you this.
The Recreational Property Use Act goes back several years, and what it actually says is that as long as you are not charging someone to be on your property, you have immunity to things that happen to them while they're on your property. So somebody on that boat, you let somebody voluntarily go over there, fish, and they fell out of that boat and they got hurt, or they did something that was intentional on the property that you had left and they got hurt. As long as you ain't charging them any money, you ain't got no liability. But the day you start charging them money, then you become a business. You're no longer doing it for charity. And that's where normal laws concerning property would apply.
Senator Further,
Yes, sir.
if I have signs up that I charge you to fish, but you fish at your own liability.
Right.
In other words, if you slip off in the lake and you can't swim, that's cause for you to get hurt messing around water.
Right.
Isn't it true that if I charge you $1 to fish, and isn't it also true if I charge you $1 to fish, I've got to replenish the fish so other folks can fish too? That if you fall in the lake and you cannot swim, then I'm held liable for you coming to fish in the lake because I charge you $1 to fish.
No, sir, that's not true. You still have to go by regular negligent laws, which means you have to have a duty, a breach, a harm, and a cause. And you would not be the cause of the harm in that instance. The person falling out of the boat, you are not, unless you were there pushing them out of the boat, you would not be the cause of the harm. So normal negligent laws would apply, and there would be most likely no liability that would be imposed on you in that instance. Thank you, Mr. President. I yield the will.
No further questions. Thank you very much. The question on the adoption of the amendment. Is there objection to the adoption of the amendment? Hearing none, the floor amendment is adopted. The question is on the adoption of the committee substitute as amended. There is objection to the. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted as amended. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? Questions on the passage of the bill by substitute. All those in favor vote yea. All those opposed vote nay. Mr. Secretary, unlock machines. On the passage of the bill, the yeas are 46 and nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read House Bill 65.
House Bill 65 by Representative Peake of the 141st and others, a bill we titled Enactment Code Section 31-2A-18 of the OCGA relating to the establishment of the low THC oil patient registry. Definitions, purpose, registration cards, quarterly reports, and waiver forms so as to change provisions relating to conditions and eligibility and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute to House Bill 65, a bill titled Enactment Article 1 of Chapter 2A of Title 31 of the OCGA, relating to general provisions relative to the Department of Public Health so as to provide for the creation of the Joint Study Committee on THC medical oil access and for other matters. Amendment 1 by Senator Watson of the First and others offers the following amendment. Amend the Senate Committee on Health and Human Services substitute to House Bill 65 by striking Committee on line 3, inserting in its place Commission by striking Committee on line 11, inserting in its place Commission and for other purposes. Amendment 1A by Senator Heath of the 31st offers the following amendment. Amend Amendment 1 to House Bill 65's committee substitute by inserting medical after the word through on line 16. Mr. President, that concludes the order.
Recognize Senator from the 28th to speak to the bill.
Thank you, Mr. President, members of this distinguished body. Present to you HB 65, which simply does one thing. We're going to create a study committee. Actually, we're going to rename it a study commission, as you'll see in your amendment, but that's going to look at how our patients that are allowed to obtain medical cannabis, we're going to seek for ways that they can actually get it here. It's going to be made up of 3 Senate members appointed by the President by the President of the Senate, as well as 2 citizens. It will be made up of 3 House members appointed by the Speaker, as well as 2 citizens. With that, I will take any questions.
You have some questions. Chair now recognizes Senator from 36 for a question.
Thank you, Mr. President. Senator Yu.
I yield.
Through the thicket of bodies that are between you and me, I think I can see you over there.
And I see you.
Thank you. Senator, this is replacing the bill that came over from the Senate, is that right, with a study committee, as opposed to the language that the bill that came over from the House to us?
That's correct.
And that bill would have added the post-traumatic stress syndrome and chronic pain as 2 more conditions that would be eligible for consideration for access to the oil.
I believe those were some of the things that were listed as well.
And isn't it true that I know I have, and I would imagine other people have heard from people in their districts that are really urgently needing access to the limited access system that we have set up right now for the cannabidiol oil. Isn't that true?
That is true.
So it's a pretty rough proposition, I think, to slam the door on those folks at this point. What do you think justifies that?
Well, I think you'll see in the amendment takes care of that. We're going to take the politics out of this and get it to the people that need to be making these decisions, not lawmakers.
Maybe you could explain the amendment that you're referencing. You
I'll
said
let
there's an amendment on our desks. Is that what you're
correct,
talking
and
about?
I'll let the senator from the 1st speak to the amendment, which I do support.
Thank you very much.
You're welcome.
Chair recognizes Senator from the 5th for a question.
To your right. Will the gentleman yield?
I yield.
So you're going to defer on questions on the amendment then until to the senator from the 1st, or are you willing to yield to questions about the amendment? 1 and 1A.
I mean, I'll yield, but if you
have
have
the amendment in front of you then?
I do.
Okay. Is it not true that on the committee substitute, the bill goes through a section 1 and then goes over through line 50 is section, on line 49 it's F, and then the amendment picks up at line 14 with adding a section H. My question, if the gentleman will yield, where's section G? And what does section G stay?
I'm going to yield to the senator who offered the amendment.
Will the gentleman yield to 2 other questions then?
About the bill?
Well, this would be about the amendments. I'm sorry, these are about.
I'm going to yield to the senator from the 1st who offered the amendment.
Take this up with the senator from the 1st.
Thank you.
Senator from the 40th, you wish to be recognized. You are recognized this time.
Senator Yield.
I yield.
Senator, isn't it true? I apologize in advance, but in reading, starting on line 11 down to the 21, it appears that one of the charges to this study committee is we're actually talking about growing in this particular bill. the planting of seeds, all aspects of the manufacturing process, product labeling, independent testing, final dispensing, and that some of us have concerns, and I apologize I didn't bring this up in advance to you, versus just we're allowing it to come into the state. So the question...
This committee will look at all possible means of getting access for these patients.
Okay. No, you answered that, and again, but I apologize for not asking that in advance.
Apology accepted.
No further questions, Senator. Chair now recognizes Senator from the 1st to speak to his amendment. Amendment number 1.
Thank you, Mr. President. The amendment number 1 is basically takes the addition of continually adding in more diagnoses and puts it in the hands of the Composite State Board of Medical Examiners. They are required to look at the research, and I am in agreement with the Senator from the 31st in his Amendment 1A, medical research, to look at whether or not it is effective. As you know, when we initially did this, we did this with the thought process that a lot of these anecdotal reports that we were seeing, a lot of testimonies that we saw, and a lot of parents just certainly believed that it was reducing the number of seizures that we were seeing in children, especially with Dravet syndrome. We did that on what our gut and our heart was telling us. Since then, as of early spring, I think it was in June, in the New England Journal of Medicine, for the first time, CBD oil has been shown in Dravet syndrome to reduce the incidence of seizures, to reduce the incidence of how much medicine is actually being used. It was done in a randomized, double-blinded, placebo-controlled study published in the most respected journal in the world and showed it unequivocally supporting the usage of that. Now, having said that, we are still tied, our hands are still tied by the federal government because this still is classified by the FDA and DEA as a Schedule I drug. They should, with that evidence, now take that evidence and either make it into a Schedule 1A or a 2A or something to allow universities and medical schools and scientists to study this in an appropriate manner so that we can show that in the dozen or so diagnoses that we have listed here in the state of Georgia that it does work or doesn't work. And that's what this amendment does. This amendment gives it to a group of professionals to look at the medical research to show whether or not it works or not. So, and having said that, they have to deliver it back to us to give it an up or down vote. So, and that's the procedure that happens, and that's what will hopefully be done. If I could follow up on, maybe I could answer your questions. The H section is in another section relating to the bill, and that's why that seems to be out of order, but it is appropriate. You have to go into the OCGA and pull it up and look at it there. It is the correct one. I looked at it just a little bit earlier in the day. But I'm happy to answer any other questions. If not, I'd ask if you're favorable consideration, and I do support Amendment 1A with the word medical in there that the senator from the 31st has proposed.
Chair recognizes Senator from the 5th for a question.
What the gentleman yield?
I yield.
So what you're saying is that even though you're amending just a different code section entirely, and there's a G
yeah, the
out
H,
there?
if you look back at on the pink sheet, it is listed there. I believe it has to do with the number of diagnoses. Let me see if I can find that. I think it's under Section 2 and of the original pink sheet, and I think it has to do with the number of diagnoses. There are about a dozen or so, and I think if you count it out, the letters do make sense there. That's from me looking at it about 2 or 3 hours ago.
Wait, if the gentleman would yield.
Yes.
Okay, I'm looking at the same thing. We're offering a committee substitute that doesn't have that at all in it. Is that not correct? That doesn't have the list that's actually listed.
No, it
section-
doesn't. In the pink, it does, but in the green,
and
it
in
did
the-
not. That's
and
correct.
in the pink, that list is section B, not G of the bill.
You know, I may be wrong on telling you that's where it comes from, but when I looked at the particular area,
Is it also
that was
not
correct.
true that this would still leave intact that this commission, as it would be renamed under the amendment, would still be abolished December 31st of 2018? That's sections E and F. Lines 45
But yes,
through...
the commission would. That's correct.
And so you're creating a commission that is going to deliver the product to the General Assembly by December 1st, although it does say annually online. I believe it's line 15, could be line 16. But it's going to be abolished. There's no annually. Is that not true? It's going to be abolished the same year that it's created. It's not.
That's
in
correct.
spite of its-
So what Section 1 does, that's forming the commission to study the access.
And so
then
that commission will be abolished on December 31st, 2018 then, according to the bill.
That's correct.
And then, so is it not true that you're basically gutting the entire bill because there's no current medical studies going on that would be completed by December 1st, 2018 that are going to yield any results, and that basically this is a way to essentially gut the bill and do nothing?
Well,
There will be no, because there are no medical studies, because there's no bill in Congress, there's no proposal there's no bill in Congress that's scheduled for a vote, where we're going to have a vote before December 1st, 2018 to reclassify marijuana or cannabis as off of Schedule 1. There are no studies in progress. There is no evidence this is window dressing, and it basically guts even the study commission. Is that not true?
I could not disagree with you further.
What studies, if the gentleman will
So
yield,
let me just-
if the gentleman will yield, what studies are in progress that could possibly be finished by this timeline that are medical studies according to 1A that would in fact yield any type of result? Do you have any
You
knowledge
didn't really
of
let
any
me,
such studies?
do you mind, could
That's
I
a
answer the
question,
question?
and I'm asking.
Answer the question. So the commission is to look at the access, and the access in the state of Georgia, and that will be reported back before December, and that commission will be abolished. The look for the diagnoses in the future will be done by the Composite State Board of Medical Examiners. That's not abolished, and that is where we keep all the dozen or so diagnoses that we have now. Future diagnoses will be added based on the medical research. And there is research that is ongoing, and it will continue to be ongoing. And yes, it does need to be, reclassified as we discussed before.
So basically, by the will the gentleman yield for?
Yes.
So basically, by the terms of this, in order to add anything else to this list, you'd actually have to get the drug reclassified by Congress.
No, not necessarily. No, because remember that the study in the New England Journal of Medicine was, and this was last summer when it was published. So, and that's before it's published, it's gone through peer review. It's batted back and forth by the editors and so forth. So that had been in the works for quite some time. And there are other studies that are ongoing. This is certainly a national and international issue, and there's multiple studies going on. But to answer your question, and I think we're both on the same page here, we're both in agreement that we think that this CBD oil, and maybe marijuana too, has medicinal purposes. It should not be in Schedule 1. It should be carved out, and it should be studied.
We are in agreement about that.
Thank you. Are there any other questions? If not, I'll yield the well.
We do have another question. Chair recognizes Senator from the 52nd.
52nd.
Would the senator yield?
Oh, gotcha.
Would the senator yield?
Yes, sir.
I appreciate your amendment and what you're doing here. I did have a question on this. We in committee had talked about the difference in what the definition of low is, with the federal definition for cannabidiol being 0.3%. The state had something they said was low at 5%, and we had agreed to take low out. And now I see it's back in here in several places.
There'll have to be a conference committee, and I'll be happy to take the low, that word out if we need to. And I understand and completely agree. Just for education purposes, the senator feels as if this 5% that we have here in the state of Georgia is not low by definition. It is lower than some others, but you're correct. It's probably middle of the road when it comes to most other percentages of the THC. And again, the THC is the portion that causes the hallucinations and delusions and so forth. It's felt that this low is not significantly causing that, but your point is well taken. Be happy to take that out in conference.
All right, thank you.
Chair recognizes Senator from the 36th. Over to your left.
Thank you, Mr. President. Senator Yield.
Yes.
Senator, we've served side by side on this committee that's had this before us on more than one occasion, isn't it true? And just looking at when we substitute this language that is before us for the bill that came from the House, there were some real significant improvements, like if you look at the pink section 2, on the pink version, the version that came from the House, cancer, when such diagnosis is end stage or the treatment disease, we're by striking all of this work that's been done by the House, we are locking us into what was passed last year and not permitting any of these enhancements that the work that was done in the House on people that are currently benefiting from this oil. Isn't that true? I mean, doesn't that pushes? I mean, it's words on paper up here, but it's in patients' lives that are coping with cancer and the dreadful pain of cancer. We're denying, by striking that language, by not including that language from the House, we're saying no to those patients. You can only have to be in
I respectfully disagree with that. I think that to open it up as you're doing, or as that is done, is we need to base this on science and not anecdotes, not associations. We need to base it on what I had alluded to earlier, the randomized controlled trials.
But it is true if you look at those. There are 8 conditions that are in the code from earlier work that we've done.
You're right. I think there are actually a dozen. I think they had changed some of those others.
Well, A through H, I count
right.
that being somewhere in the
right.
8, and then
that was
and then there were
changed
others
legislation.
added.
I think there are about a dozen now.
Well, the ones the ones.
I see what you're looking at. Yes, ma'am.
Lines 35 through, and having family members suffering with Parkinson's, the pervasive sickle cell disease that's all around us in the population. We started out very cautiously saying end stage. Now, when we keep that language as it is in the code currently, we are in effect denying patients with Parkinson's or sickle cell disease, just to mention 2, or multiple sclerosis, access unless they're in the very end stage. That's what it just seems that we're, rather than going forward, we're taking a step backward, and also having the language in there that's now stricken in the new language over on 76 and 77, dealing with individuals in a hospice program.
Thank you. Yes, ma'am. Again, let's go to away from anecdotes. My dad died of Parkinson's disease. So did my father-in-law, and that is certainly near and dear. I understand that. I have patients with sickle cell disease. I got you. But until we look at the science and not look at the last patient we treated, we need to look at this objectively. Mr. President, if there are no further questions, I'll yield the well.
Senator has yielded. Chair recognizes Senator 27. Speak to the bill.
Thank you, Mr. President. I stand in objection to this bill. Again, I just want to reiterate some of the things that have already been said about what we are doing by replacing the bill, the study committee. We're replacing the study committee with real solutions to people's lives. people that are currently suffering cancer, the end stage. We're saying that you can have this medical cannabis oil at the end of your life, but not during your life, so that we can improve the quality of your life. That doesn't make any sense to me. Why do we not move forward with the bill? Why are we telling people with Tourette syndrome, autism spectrum disorder, Alzheimer's disease, HIV, acquired immune deficiency syndrome, why are we telling these people you cannot have access to this medicine? Let us study it some more. Let us continue to talk about it. Not only that, this amendment passes the buck to other people to make the decision. We have the ability to improve the lives of Georgians with the bill that came over from the House. We don't need to study it any longer. What we need to do is be a committee and be a body of action and not words. So with that, Mr. President, I yield the will.
Question is on amendment number 1A. 1A. Is there objection to amendment 1A? Without objection, amendment 1A has been adopted. Question now is on amendment 1 as amended. Is there objection? There is objection. Objection by the senator from the 5th. All those in favor of Amendment 1 as amended, rise, stand, and be counted. If you are in favor of Amendment 1 as amended, rise, stand, and be counted. Reverse. On Amendment 1, the yeas are 26, the nays are 12, and the amendment has passed. Number 1 as amended. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Senator for 26, your eighth, your light's on. Is there a purpose? I wouldn't worry about it. Does any other senator wish to speak for or against the bill? Is there objection agreed in the Port of Committee which fail to pass the bill? Chairs none. Port of Committee is agreed to. Shall the main question be now put? Are there objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. Yeah. On the pass of the bill, the yeas are 31, the nays are 17, and this bill, having requisite constitutional majority, is therefore adopted. Appreciate the Senate's good work on this bill, obviously working to grant access to so many individuals across our state in a safe and secure manner. Chair recognizes Senator from the 4th.
Mr. President, I move the Senate adhere to its disagreement to the House Bill 684 and that a conference committee be appointed.
Read the caption.
House Bill 684 by Representative Ralston the 7th and others, a bill will be titled an act to make and provide appropriations for the state fiscal year beginning July 1st, 2018 and ending June 30th, 2019 for other purposes. That concludes the order.
Is there objection? Without objection, the conferees to House Bill 684 will be the senator from the 49th, senator from the 46th, and the senator from the 4th. Secretary will read House Bill 93.
House Bill 93 by Representative Corbett of the 174th and others, a bill we titled enactment code section 48.235.1 of the OCGA relating to refunds of sales and use taxes, would provide that no interest shall be paid on refunds of sales and use taxes to a purchaser that held a certificate or exemption letter if such purchaser did not use such document and for other purposes. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 93, a bill we titled enactment Article 2, Chapter 2 of Title 40 of the OCGA relating to administration of revenue and taxation, so as to provide that interest shall be paid on certain refunds of sales and use taxes to certain purchasers under certain circumstances, to amend Article 3, Chapter 5, Title 20 of the OCGA relating to fiscal bills generally, so as to require an economic analysis prior to the induction or amendment of legislation containing tax incentives and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 56th to present the bill.
Thank you, Mr. President. I bring you House Bill 93 today. This is a combination of a few bills. The first is simply saying if somebody had paid their taxes and were due a refund, that the refund time would start at the point of paying their taxes to make sure folks weren't looking back many years just for the purpose of collecting interest from the state. And then the second two parts of bills we've already passed from this chamber, which were Senate Bill 378 and 432, which was the Georgia Measuring Success Act, as well as the Business Case Act, which was for us to measure each one of our tax incentives every 5 years, as well as a business case process before we adopted those. This was the output from our Senate Study Committee over the summer to be good fiscal stewards. If there are no questions, I'll yield the well.
There are no questions.
Thank you, Mr. President.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree in the Report of Committee which failed to pass the bill. Chairs none. Report of Committee is agreed to. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 49, the nays are 0, and this bill having received requisite constitutional majority is therefore adopted. Secretary will read House Bill 374.
House Bill 374 by Representative 90 of the 130th, the bill we titled enactment Chapter 5 Title 40 of the OCGA relating to ad valorem taxation of property, so as to allow for electronic filing of returns in certain cases, provide for certain changes in proceedings before the County Board of Equalization for other purposes. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 374, a bill titled enactment Chapter 5 Title 40 of the OCGA relating to ad valorem taxation of property, so as to provide for certain changes in proceedings before the County Board of Equalization and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 28th present the bill.
Thank you, Mr. President. Members of the Senate, rise to present HB 374. The intent of this bill is to simply clarify previous laws related to ad valorem tax and the appeals process. We do this in a couple of ways. One, we're lowering the threshold of property values that can be heard by the hearing officer with the appeal to the Superior Court. We're taking that from $750,000 down to $500,000. Current law requires the assessor to notify the taxpayer within 180 days if there are changes or corrections to the valuation. This simply is going to require the tax assessor to notify the taxpayer within 100 days also if there are no changes. It also acknowledges that if the tax appeal is on property that makes up 3% or more of the gross tax digest of the county, the Board of Tax Assessors can be granted over 180 days, but in order to do so, they will have to notify within 30 days before that 180-day period.
No question, Senator.
Thank you.
Question on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agreed on report of committee which fail pass the bill. Chair is none. Report of committee is agreed to. All those in favor of the bill vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the ayes are 46, the nays are 0. And this bill, MC Rex constitutional majority, is therefore adopted. Secretary will read House Bill 314.
House Bill 314 by Resident Shaw, 176 and others. The bill will be titled enacted in Chapter 1 of Title 33 of the OCGA relating to general provisions regarding insurance so as to establish qualified low-income community investment, provide for a short title, provide for definitions, provide that certain entities may earn credit against the entity's state tax liability to disallow refundability sale on the open market of claim credits, provide for certification of qualified capital investments and for other purposes. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 314. The bill will be titled enactment Title 33 of the OCGA relating to insurance so as to establish standards for carriers and healthcare providers with regard to payment under a managed care plan in the provision of emergency medical care, to provide for applicability, provide for definition, provide for certain patient or prospective patient disclosures, and for other purposes. Amendment 1 by Senator Untom, Amendment 45th offers the following amendment. Amend the House Senate substitute to the House Bill 314 by striking on line 79 all and insert allowed. Mr. President, that concludes the order.
Chair recognizes Senator from the 52nd to present the bill.
Thank you, Mr. President. This bill is the exact same word-for-word bill of Senate Bill 359, which was passed out earlier in this session by the Senate body by a vote of 52 to 0. It allows for a transparency portion, requirements by the physicians, by the hospitals, and by the insurers. It sets up a mechanism, an independent database that is not run by physicians or hospitals or insurers, that then would be used in the case of emergency out-of-network care. And in the case of elective care, it sets up a mediation, which also can use a teleconference method for any bill that's over $1,000. This has been used successfully in New York and in Connecticut, and this has not caused people to go out of network. In fact, the opposite is true. Georgia is #1 in the country, according to the University of Pennsylvania, in out-of-network plans. Connecticut, which uses it, has 0 narrow networks in that. This has been successfully used in other states. I've heard there may be amendments. I know I've heard of one, which I don't think it would work at all. I think it's problematic, and so I would ask that you don't support that amendment. And I can speak to that at a later point if that amendment has been discussed, but it would change the definition, and allowed charges really wouldn't work in the case of out-of-network because there's no allowed charges. It's hasn't been negotiated between the two parties. Mr. President, if there's no questions, I'll yield the well.
No question, Senator. Did you speak to the amendment, or Senator from, well, yeah. Chair recognizes Senator from the 45th speak to her amendment.
Thank you, ladies and gentlemen of the Senate. Well, here we go. Here we go, talking about health care, talking about insurance, talking about providers. And it is so interesting. I brought up, because we have been working on this issue for 4 years now. And this is just a small amount of the background. This doesn't include what's on the computers. But these are the files that I have pulled about surprise billing. And everyone has heard about surprise billing because Senate Bill 8 has been around for 2 years now. And unfortunately, when I go to all these hearings and call these hearings, both sides show up, of course. The providers, the doctors show up over here. And over on this side is the insurance companies. And I cannot tell you how many meetings we have had. But one thing I can tell you, that is for sure, the one that is right in the middle is the consumer, is the patient. And guess what gets left out in every single meeting? It's the patient. And the legislators that go to this meeting, we come out bloody because we're absolutely torn apart. Who do you choose? Who do you believe? Who do all these files, all this information, who do you believe in the story? Who's telling the truth? But I can guarantee you one thing, the truth is not in fairness to the patient. Not one time in these meetings do you hear the patient talked about. You hear the hospitals talked about, Hospitals 101. You hear the doctors talked about with fair health, which is their choice. And then you hear the insurance companies. And you hear about insurance companies making billions and billions of dollars. And all you hear about when you're a legislator and you go to these meetings is the dollar bill, the reimbursement rate, and who gets reimbursed. You don't hear about quality of care. You don't hear about this in-network, out-of-network. When you're out here on the expressway and you have your collision and the ambulance comes and picks you up and takes you to the emergency room, when you get to the emergency room and you're bleeding to death, does your family or do you, when you're unconscious, do you think about, is this emergency room doctor in network or out of network? You don't care. Your family doesn't care. You just want to be saved. And lo and behold, thank goodness you are saved. But lo and behold, whether you stay in that emergency room for 8 hours or you stay in that hospital for 5 days, guess what? You may have insurance. You may have met your deductible. But when you get home, you got your surprise bill. And your surprise bill is over and beyond the contracted price that that doctor and that hospital and that insurance company agreed to. And guess who has the bottom dollar? You. And it doesn't matter if you've got enough money to pay for it or not, because they will go after you, the creditors. By the time 30 days is over, they're already calling you with the creditors. There goes your credit rating if you can't pay. Yeah, they'll make plans for you, but you may be paying for the rest of your life to pay off of that car accident. So, where are we? What I would like to see, there's a bill in the House, and they're working on it now, and both sides, sure enough, insurance over here, providers over there. Doctors versus insurance companies, they're fighting it out right across the hall in Senate Bill 8. The doctors want fair health. What is fair health? We actually had these people come down here to Georgia. They're based in the Northeast, and we had them come and educate us about fair health. And it is a balanced scheme. And then we had our own insurance companies here in the state of Georgia. Well, guess what? They conflict. And what the senator from the 52nd is trying to do is to reach a balance. And the bill that is before you is pro-doctor. It is pro-doctor, and it's anti-insurance. I don't want to pick a side. I don't want to pick a side. I'm for that person that's right there in the middle. It's your constituents that I'm for. It's not the doctors, it's not the hospitals, it's not the insurance company. It's the people that we represent. It's the consumer. And that's who we are beholden to, and that's who we should be looking after. I'm going to vote for this bill. I'm going to vote for this bill because I want it to go to conference committee. Guess what? The state of New York has resolved this problem. If the state of New York can do it, the state of Georgia can do it. The state of Florida has resolved this problem. 20 million people. It is very much pro-consumer in Florida. There is no reason why the state of Georgia cannot resolve this problem. So before you have an amendment. And what this amendment does, it strikes the word allowed charges and has all charges. We will base provider reimbursement on the market rate negotiated between these two parties, the doctors and the insurance companies, between the doctor and the health plan. This is what they signed. They sign a contract saying, yes, I will be in agreement with a certain insurance company, and yes, I will accept these charges. But guess what? All of a sudden, you get a bill. They really didn't accept those charges. And that's what balanced billing, that's what surprise billing is all about. That is what medical bankruptcy is all about. That is what changes your credit rating. Bill charges can be 2 to 3 to 5 times higher. When you're talking about the emergency room, it can be 2 to 3 to 5 times higher. Which providers usually do this? It's radiologists, anesthesiologists, pathologists, but the most frequent abuser of this is the emergency rooms. So what I'm asking you for is to look at amendment number 1. Is that amendment number 1? Yes, amendment number 1. And that changes it to all charges so that they can't bump up those extra charges. It has to be the agreed upon charges. So, Mr. President, I'll be glad to answer any questions. I do have a form up here that shows in the emergency room in the Atlanta area in 2017, the Medicare rate for an emergency room when you have that accident like I was talking about, the Medicare reimbursement rate is $175. 80% of the allowed charges, which is what this amendment addresses, is $431. 80% of the billed charges is $1,180. So you can see there's a big difference. And what it does, it saves consumers money if you do that amendment. I'll be glad to answer any questions.
Chair recognizes Senator from the 41st for a question.
Senator Yield?
Yes.
Senator, don't you have any concern that this amendment might confuse things? First of all, if they don't have an agreement, they don't really have a list of allowed charges, so that the amendment might be confusing and undermine the intent of the bill?
Well, I will say I'm thinking about withdrawing the amendment because I do want it to go to conference committee. Unlike these meetings that I've had down in the basement of this building where they come together and it ends up being a bloodbath, hopefully the senator from the 52nd can get these people together and say, look, we mean business. We're looking after the consumers of the state of Georgia. So yes, it is very confusing. And if I hadn't sat up here and I hadn't sat through all these meetings and learned the insurance industry and learned billing practices, I would be very much confused. But yes, you are correct. It is very confusing.
Thank you, Senator. If you would, one further question.
Mhm.
Is it not true that I appreciate your fight for the Georgia consumers and that the bill will be going to conference committees, or at least we'll have the opportunity since we have a committee substitute, and I, like you, hope we can improve things for Georgia consumers. Is that not true?
Thank you very much. And I appreciate there has been a group, the Georgia Health Foundation, that has been working on this, and I appreciate them working with me. They are very much pro-consumer. There's very few groups out there. There's a lot of people who get paid big money to represent both sides of this equation. But guess what? There's not very many people that get to represent the consumer. And that's why Georgia's in the state we're in. And that's why you have so many people in medical bankruptcy and so many people that have medical bills. And that's why you see I've gotten hundreds and hundreds and hundreds of emails yesterday and today. And unfortunately, like you say, it's very confusing. And they skew the debate. And they frame the debate the way they want to get an answer. So the consumer is confused. But they're not confused when they're in that accident and they're bleeding to death and they're losing their loved one. And then they get home and they get that bill. They're not confused at all. But this is all about reimbursement and all about the almighty dollar.
Chair recognizes Senator from the 40th for a question.
Senator Yield for a couple of questions.
Yes, sir.
If I understand this properly, Senator from the 41st asked about if you're not signed up with a particular insurance carrier, but as long as the commissioner has some kind of benchmark data thing,
Right.
you don't have to be signed up as long as he's got access to information. Is that true?
That's true.
Is it further true that if I recently got a bill, I think it was for $30,000 based upon a procedure, and I have insurance.
Right.
So with my insurance, is it not true that ended up being $1,000? My question is this: I have insurance.
Mm-hmm.
The consumer that doesn't have insurance gets the $30,000 bill.
Mm-hmm.
What do they do?
Those are the people that I'm talking about with medical bankruptcy. But you can think you have insurance. You can think you have good insurance. But then when you go in for your cardiovascular surgery, you got chest pain, you have your stents, or you have grafts put in your heart, and your bill is $100,000. And you think you have insurance, but you got a second assistant that is right there helping your cardiovascular surgeon, and he is out of network, and then you get another bill for $20,000 because he's out of network. That's part of the problem.
One final question.
Yes, sir.
It seems to me, if I remember in committee, and correct me if I'm wrong, we looked at various percentiles in the committee. And the highest reimbursement rate that we found, I believe, was the one out of New York, which was 80%. Was that correct?
Yes, that's
and
called
we looked,
the Fair
did we
Health.
not, furthermore, did we not look for ranges somewhere from, was it 40 to 80%? And the bill at this point is at the 80%. Is that correct?
That's exactly right.
Thank you.
Thank you, Mr. President, and hopefully this bill is going to go to conference committee, and hopefully, I know those people are going to show up. The insurance and the doctors are going to show up, but I have full confidence when those people are appointed on those conference committee that they're going to represent the consumers of Georgia. With that, Mr. President, I withdraw amendment number 1.
Thank you, Senator. Let me have the senator from the 9th speak first to the amendment number 2.
Thank you, Mr. President. I'll try to be as brief as possible. A couple years ago, I worked on a bill for provider directories and brought together providers, hospitals, and insurers. When this was brought up to me, there's one participant that was left out, and I thought that should be corrected, and that is hospitals that are also out of network. When you look at this amendment, it does two things. First, it adds a definition of a non-participating hospital, and secondly, it deletes the entire paragraph. There's only a couple of changes in that paragraph, but then it rewrites as such. And what that does is it includes out-of-network or non-participating hospitals, and then it puts in a requirement that the insurers be notified, because a lot of times they may not even know that they have an insured that's actually in the hospital there, and so they may not be able to make sure they're receiving the best possible care, or even approve charges that would be normally up underneath their plan. So what it does is it just requires notification. Once that person has become stable, they're notified, and then they can make other arrangements. It creates that conversation so that the hospitals or the doctor can make arrangements with the insurer, and we can make sure they're receiving the best care and hopefully at the best price. If there are any questions, I'll accept them now or I'll yield the will.
Chair, recognize Senator from the 45th for a question.
With the Senator yield?
I will.
Senator, is your amendment number 2, and I appreciate you writing, and I'm not saying I disagree with it, but it was specifically written for a specific entity, Kaiser, which is located in our county. Is that not true?
I'm not sure that it would only apply to them, but they've helped me on this.
Senator, would you further yield?
I will.
Senator, isn't it true that of the 180-something thousand students in Gwinnett County, that most of them are taught by teachers, and the majority of those teachers love Kaiser? Is that not true?
I'm sure you know of what you speak.
Would you further yield?
I will.
Senator, in the spirit of cooperation, I withdrew amendment number 1. Would you be amenable to withdrawing amendment number 2, and when this goes to conference committee, that your amendment will be duly considered along with amendment number 1? Would you be willing to do that?
Seems reasonable. I'll consider it. I have a walk back to the desk. I'll yield the well. Thank you, Mr. President.
All right, perfect. Hey. All right. Thank you for everybody being sensitive of the time. Chair will recognize Senator from the 45th first to withdraw Amendment 1.
Thank you, Mr. President. I ask the motion to remove amendment number 1, please.
Is there objection? Without objection, Amendment number 1 will be withdrawn. Chair recognizes Senator from the 9th.
President, I would ask unanimous consent to withdraw amendment number 2.
Is there objection? Without objection, Amendment number 2 is now withdrawn. Question now is on the adoption of a committee substitute. Is there objection? Without objection, committee substitute is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree to report of committee which fair will pass the bill. Chair is none. Report of committee is agreed to. All those in favor of the bill vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 47, the nays are 1, and this bill, having received requisite constitutional majority, is therefore adopted. Secretary will read House Bill 410.
House Bill 410 by Representative Powell, the 32nd and others. The bill will be titled an act to amend Chapter 3, Title 44 of the OCGA relating to regulation of specialized land transactions so as to provide for limits on certain fees imposed on purchasers of condominiums and lots in a property owners association and for other purposes. Mr. President, Senate Committee on Judiciary offers the following substitute to House Bill 410. A bill will be titled an act to amend Chapter 3, Title 44 of the OCGA relating to regulation of specialized land transactions so as to provide for fees for statements of amounts owing to a condominium association, property owners association, and similar associations, and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 3rd to present the bill.
Thank you, Mr. President. Georgia law allows condominiums and subdivisions that have protective covenants and make assessments to have a lien for unpaid condo dues or homeowners assessments. Under current law, if a buyer or seller is selling a property and the closing attorney is working on the closing, he will want to get a statement of whether or not those dues are past due, are there any liens against the property? Because if that transaction occurs and the buyer takes the property, the law would say that that lien goes with the property and it would have priority over the deed to secure debt that the purchaser had incurred when he bought the property. And so what this law does is it clarifies what can be required. It increases the fees that an association can be paid. So, current law states that the association can charge $10 for a statement of an account. Now, it doesn't detail what is included in the statement of account. What we've done in this bill is just using common sense, laid out what should be included in that statement. And if you look at lines 49 through 68, you'll see that things such as the date of the issuance, the name of the unit, you identify the unit, and then you state what dues are owed. Are there any special assessments? You would need to know that in order to properly complete that transaction and ensure that there are no liens against the property. Now, sometimes a buyer or a bank or an attorney may want to obtain additional information. We've laid that out in lines 72 through 82, such as, are there violations of other rules, a copy of the insurance policy, a copy of the protective covenants. If you're requesting information on the statement of the account, you can charge up to $100 for that. If you request the additional information, you can charge up to $50. And you need to understand that these associations, they're hired to gather this information, to make sure that people are paying their dues when they're being assessed. And so they already have all of this information. It's just a matter of ensuring that this information is made available to a purchaser of the property so that he can ensure that he can buy this property without any liens. We think that increasing this fee from $10 to $100 is certainly acceptable and is necessary to ensure that these closings can continue.
Senator,
I yield the will, unless there are any questions.
No questions, Senator. You were successful in talking long enough to get yourself 2 amendments. Secretary will read Amendment 1 and 2.
Amendment 1 by Senator Martin of the 9th offers the following amendment. Amend the committee substitute to House Bill 410 by replacing lines 43 through 46 with the following. 2, a statement of account shall be completed by an authorized agent, authorized representative, or employee of a management company authorized to complete such a statement of account on behalf of the Board or Association. If the Board or Association is not employing a management company who completes such statement, this subsection shall not apply to such Board or Association for other purposes. Amendment 2 by Senator Martin of the 9th offers the following amendment. Amend the Senate committee substitute to House Bill 410 by replacing $100 with $175 on lines 106, 212, and 311. Mr. President, that concludes the order.
Chair recognizes Senator from the 9th to speak to his amendment, Amendment number 1. Hold on, I've already recognized him. No, they're late arriving. They're late arriving. We just received them. We're putting them up on the board.
Thank you, Mr. President. This is the first amendment, Amendment 1, is an amendment that would allow for volunteer homeowners associations to not be subject to this. A lot of these folks are, a lot of these neighborhoods, particularly in my area, they're struggling to stay afloat. So what I wanted to do is make sure that we're not putting undue pressure on them. I think that the new language is, there's a lot more to it than the original language that was there prior to this bill, and this would exempt them from that piece. And I'll go ahead and speak to the second amendment as well, which basically, the original fee that passed the House was $250. And on this one, we struck $100, and we tried to compromise and put in a fee of $175. I'll yield for any questions.
You have a question. Chair recognizes Senator from the 23rd.
Thank you, Mr. President. Will the senator yield to a series of questions?
I will yield.
All right. Isn't it true that I don't know the actual cost to the homeowners association to provide this documentation?
I believe that's true.
Isn't it true, though, the statute that's been in effect since the 1970s, I believe, provided for statement of accounts at $10, is that correct?
That's correct.
And since then, isn't it typical that a number of additional items are requested by lenders and other parties in these sale transactions?
That's correct.
And isn't it true that very few states set a cap on closing costs or portions of closing costs such as these.
That's correct.
Isn't it true that the bill that passed the House provided for a $250 cap?
That is correct.
And isn't it true that the complaints we've been hearing are primarily against management companies and not the associations themselves?
That is correct.
And isn't it true that most of the associations are nonprofit?
That's correct.
And isn't it true that if the immediate parties to the sale transaction don't shoulder the full cost, the cost will be spread across all homeowners in the association?
Yes.
Thank you.
Thank you, Mr. President. I hope you'll support my amendments. I yield the will.
Chair can I Senator from the 3rd to speak, close the debate.
Thank you, Mr. President. I oppose the amendments. Amendment number 1 exempts out developments that don't hire a management company. But there's more to the bill than just setting the fees. It requires these associations to provide that statement of account within a defined period of time. If you don't do that, they may take 60 or 45, or they may not get to providing a statement of account. And this would delay a closing. So you could have a homeowner that owns a condominium that wants to sell his property, but he can't sell it because he can't get the statement of account out of the development. Point number 2, if you look at what is provided on the statement of account of what is required for $100, it just has to do with how much money is owed for the dues assessed against that unit. The association already has this information. They have to have it in order to properly manage the condominium or the home or the subdivision. Without it, they wouldn't know who owes dues or what's owed or who's behind. So to say that this is going to really increase a burden on these associations is just not true, because they already have this. And we went through this in committee, and we determined that $100 is a reasonable fee to pay to provide information that you have already accumulated and acquired. Now, a lot of these other states that charge higher fees, they require these associations to provide a lot more information that we've stated right here. We've just taken and we've detailed what, by common sense, should be included in the statement of the account. I would ask that you all vote against both amendments. Thank you, Mr. President.
The question is on amendment number 1, authored by the senator from the 9th. Is there objection? There is objection to amendment number 1, authored by the senator from the 9th. All those in favor of amendment 1 will rise, stand, and be counted. If you are in favor of amendment 1. Oh. Reverse, reverse, reverse. On amendment number 1, the yeas are 14 and the nays are 21, and amendment has lost. Now the question is on amendment number 2. Is there objection? There is objection by the senator from the 3rd. All those in favor of increasing the fee will rise, stand, and be counted. Reverse. On amendment number 2, the yeas are 9, the nays are 32, and the amendment is lost. Question now is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree and report to committee which failed pass the bill. Chairs none. Report to committee is agreed to. Shall the main question be now put? Any objections? All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. On the passage of the bill, the yeas are 45, the nays are 5, and this bill, MC Rex Constitution majority, is therefore adopted. We have some special guests that have arrived in the Senate, and we would like to take a moment to recognize a very, very special member of this body. Has done such a great job for so many years. Secretary will read a resolution.
Senate Resolution 113 by Senator Miller of the 49th and others. A resolution commending and honoring Ms. Debbie Ewing for outstanding public service and congratulating her on the grand occasion of her retirement. Whereas Debbie Ewing is a well-known employee of this body as a dedicated and capable Assistant Secretary of the Senate, and whereas Debbie was first employed as a session employee in the office of the Secretary of the Senate in 1993 and became a full-time employee in 1999, whereas Debbie has continued to work in the office of the Secretary of the Senate until 2007 when she transferred to the Legislative Fiscal Office, and whereas Debbie was transferred to the Department of Community Health where she served as Executive Assistant to the Commissioner, and whereas upon appointment to Secretary of the Senate, Debbie accepted the request of the Secretary to become the Assistant Secretary and returning to her roots with this body. Debbie has extensive knowledge and experience from her years of service of this body and was instrumental in establishing the legislative management system, and where she oversaw the conversion to desktop publishing and the process of maintaining the Senate Journal. Now therefore be it resolved that the members of this body recognize and commend Debbie Ewing for her 25 years of outstanding public service and extend to her their sincere best wishes for health and happiness in her retirement. That completes the order.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. We are so honored to recognize Debbie Ewing here today in the chamber. This is a lady who has given so much service to the state, but obviously to the state Senate as well. And we're all going to miss her deeply in her retirement. But Bob got an early jump on her, and she told me earlier today that they are planning building a house in the mountains, and they're going to spend more of their time up there. But it's great to have the entire family here, and you can see why Debbie wants to get quickly back to being with these grandkids and experiencing the love and the joy in which they bring you. I told each of them that I get to see them on a regular basis, but it's through that computer over there because she watches them, and it's a great, great honor. She is a beautiful, beautiful lady on the inside and out, and we are honored to have recognize her today. So, Debbie, congratulations on how you're doing. You can say a word.
first to the Secretary of Senate's office for taking a chance on a stay-at-home mom 25 years ago.
You know, you've seen me do this before. Just work it. You'll be fine.
And thank you to my children for enduring so many subpar dinners during session growing up. They all endured it with grace, and my daughter even worked here a couple of years, so she began to understand what it was like. And thanks to my husband, who I would not have met had I not been here, and for all the advice he's given me, and for all the times he listened to every issue that I had, and all the texts that he was getting during session at times asking him about procedures. And just, it really means a lot to me to have my moms with me. My dad can't be with me right now, but I know he's with me at heart. And really, I think if you look behind me, you see the reason that I'm leaving. I want to be with these people, and I want to spend more time with them. And I came across a quote the other day that I'd like to share with you. Just really hit home with me. And it said, "Suddenly you know. It's time to start something new and trust the magic of beginnings." And that's what I'm doing. Thank you so much.
All right. Well, Sandy, well done. Thank you. Beautiful. Well, let's try to set my own steps and get a. Secretary will read House Bill 489.
House Bill 489 by Representatives McCall, the 33rd, and others, a bill entitled Enactment Title 36 of the OCGA relating to local government, so as to provide that the Georgia Procurement Registry shall be used in addition to the official legal organ and other media outlets for advertisement of certain bid opportunities for goods and services in public works, construction contracts by a county, municipal corporation, or local board of education, and for other purposes. Mr. President, Senate Committee on Economic Development and Tourism offers the following substitute to House Bill 489, a bill entitled Enactment Title 36 of the OCGA relating to local government, so as to provide that the Georgia Procurement Registry shall be used for the advertisement of certain bid or proposal opportunities and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 28th.
Thank you, Mr. President. Members of the Senate, this bill simply requires state and local public works contracts to be advertised on Georgia's DOAS procurement registry. It's free to the contractor and it's free to the public entity that will be doing the advertising. It still allows for the legal organ to be used or any other internet site. It just simply doesn't require it. With that, I'll yield for questions.
Question is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Is any other senator wish to speak for or against the bill? Is there objection? Read a report of committee which failed pass the bill. Chair is none. Report of committee is agreed to. All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. On the passage of the bill, the yeas are 46, and the nays are 1, and this bill MC records constitutional majority is therefore adopted. Chair recognizes Senator from the 51st. We're going to try to, we have a 402 that we're going to try to get to insist so we can get in the conference committee. We recognize Senator from the 51st.
Thank you, Mr. President. I move that the Senate disagree to the House substitute to SB 402.
Disagreeing, read the caption.
Senate Bill 402 by Senators Gooch of the 51st and others, a bill we titled an act to enact the Achieving Connectivity Everywhere Act to amend Titles 32, 36, 48, and for other purposes, Mr. President, that concludes the order.
Is there objection? Without objection, the Senate has disagreed. Send it back to the House. Secretary will read House Bill 571.
House Bill 571 by Representative Watson, the 172nd and others, a bill we titled enacted in Chapter 25, Title 47 of the OCGA relating to the Magistrate's Retirement Fund, so as to provide that a member in arrears for dues payment for a period of 90 days shall be suspended from the fund, must apply for a reinstatement, provide for elections for designated survivors' benefits, and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 8th. Present the bill.
Thank you, Mr. President. We have another good little retirement bill here. This one's for the magistrate court judges. It's basically two parts. One of them allows them to, if the people are not current with their dues, it suspends them. The other provision allows them the flexibility upon retirement to draw that out under several options. Any questions? I'll try to answer. Otherwise, I'll ask for your favorable consideration.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is the objection agreed and report of committee which fair will pass the bill? All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 0. And this bill, MC records constitutional majority, is therefore adopted. Secretary will read House Bill 696.
House Bill 696 by Representatives Kelly of the 16th and others, a bill we titled an act to amend Code Section 48.83 of the OCGA relating to exemptions from state sales and use taxes so as to create an exemption for certain computer equipment sold or leased to certain entities for use in high technology data centers and for other purposes. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 696, bill we titled an act to amend Code Section 48.83 of the OCGA relating to exemptions from state sales and use taxes so as to create an exemption for certain equipment to be incorporated or used in high technology data centers and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator in the 51st. Present the bill.
Thank you, Mr. President. Senators, HB 696 is a bill that we've been working on through this session. It helps us with some of our rural broadband expansion, but it primarily deals with data centers. Data centers are becoming a big thing in our country, obviously with all the data that you store on your cell phones and your computers. A lot of it's in the cloud. Most of this information is going to data centers throughout our country. Georgia is one of the only states in the Southeast that doesn't offer sales tax exemptions and incentives. This bill will set up a tier system to attract the data centers to Georgia It has a three-tier system set up for the first $250 million project in a county over 50,000 in people. They will qualify for the sales tax exemption on the equipment that they put in the data centers. If a data center locates to a county under 50,000 people and they spend at least $150 million, they would qualify. And if they spend at least $100 million in a smaller county, less than 30,000 people, they would qualify for the sales tax exemption as well. This bill requires that the DOT, or the DOR, the Department of Revenue, set up an exemption certification that must be applied for and given to the applicant prior to the expense being invested into the data centers. There's also an annual reporting requirement in the bill, and there's other provisions in the bill that requires the Department of Revenue Commissioner to guarantee a performance bond to be put up to $20 million for the project before the certificate is issued. Mr. President, I'm glad to entertain any questions.
No
that there may
questions,
be.
Senator.
Thank you.
Question on the adoption of the committee substitute is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree in report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. On the passage of the bill, the yeas are 42, the nays are 5, and this bill having received Rex constitutional majority is therefore adopted. Secretary will read House Bill 721.
House Bill 721 by Representative Powell, 32nd, and others. The bill will be titled and acted in Code Section 4527 of the OCGA, relating examination of applicants so as to revise the criteria by which the Department of Driver Services shall authorize licensed driver training schools to administer the on-the-road driving skills testing for other purposes. Senate Committee on Public Safety offers the following substitute to House Bill 721, a bill will be titled and acted in Code Section 4527 of the OCGA, relating to examination of applicants so as to revise the criteria by which the Department of Driver Services shall authorize certain licensed driver training schools to administer the on-the-road driving skills testing for other purposes. Amendment 1 by Senator Albers, the 56th, and others offers the following amendment. Amend the Senate Committee on Public Safety substitute to House Bill 721 by replacing line 32 with the following. Provided for and approved by the Department, or Amendment 2 by Senator Albers of the 56th and others offers the following amendment. Amend Committee substitute to House Bill 721 by striking the word 5 on line 14 and replace it with 2, and striking 5-year on line 15 and replace with 2-year. Amendment 3 by Senator Albers of the 56 and others offers the following amendment. Amend Senate Committee substitute to House Bill 721 by striking on line 17, starting with the word provider through line 21, ending with the word period. Mr. President, that concludes the order.
Chair recognizes Senator from the 56 to present the bill.
Thank you, Mr. President. House Bill 721 just makes a few minor changes to the private driver training schools. And if you look toward the back of the bill, you'll just see that it gives 3 different options for how they do that today, which is a combination of either in the classroom, online, or through driver services, and then the amount of time they need to be driving with an instructor of 6 hours or 40 hours of their parents. There was one other part of the bill that we went back to the original, which says you have to be in business for 2 years' time in order to provide these services, and that is governed by driver services. We didn't want to stifle the competition of those newer companies because they'd have to be approved by Georgia Driver Services anyway. Amendment number 1 was a clerical error. I want to thank the Pro Tem's office for finding that. In the bill it said and, but it should have been or between the 3 options. And then amendments 2 and 3 just simply bring that 5-year back to a 2-year window so we can be pro new small business. If there are no questions, I'll yield the well.
Thank you, Senator. No questions. Question is on amendment number 1. Is there objection? Without objection, amendment number 1 is adopted. Now the question is on amendment number 2. Is there objection? Without objection, amendment number 2 is adopted. Question now is on amendment number 3. Is there objection? Without objection, amendment number 3 is adopted. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection agreed and report of committee which fail pass the bill? Chairs none, report of committee is agreed to. Shall the main question be now put, or the objections? Chairs none, main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill, vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 43 and the nays are 1. And this bill, having received records constitutional majority, is therefore adopted. Secretary now will read House Bill 760.
House Bill 760 by Representative Lunston of the 12th and others, a bill to title an act to amend Chapter 24, Title 33 of the OCJ relating to insurance generally so as to revise certain definitions or to clarify renewal, non-renewal, and reduction in coverage applicability of certain automobile policies and property insurance and for other purposes. Mr. President, Senate Committee on Insurance and Labor offers the following substitute to House Bill 760, a bill we titled an act to amend Chapter 24, Title 33 of the OCJ relating to insurance generally so as to revise certain definitions to clarify renewal, non-renewal, and reduction in coverage applicability to certain automobile policies and property insurance and for other purposes. Mr. President, that concludes the order.
Senator from the 14th is not present. Who was supposed to present this bill? Someone was supposed to present it, I believe. Were you? Senator from the 9th, was it you? Your success rate this session has been pretty poor, so maybe we should find a... You're not sure? Give it your best effort. Expectations are not very high, I can assure you.
Thank you, Mr. President. The love is flowing today, I can tell. I'll be very brief as I can. There's a situation in the insurance industry where if there's any reduction whatsoever in coverage, the insurance company is required to send a notice of cancellation or non-renewal, which is very confusing to policyholders. It can create alarm. And so the industry came and said, hey, we want to create a new form that is a notice of reduction of coverage. If they are eliminating coverage completely, they still have to send the non-renewal. But if they're just reducing a coverage or a small amount, then they would send the reduction of coverage notice instead of the non-renewal cancellation to hopefully clear up confusion with consumers. If there are any questions, if there are no questions, I'll yield the will.
No questions. Chair recognizes Senator from the 26th.
Thank you, Mr. President. Ladies and gentlemen of the Senate, this is a bad bill. It's just bad policy. Let me tell you what happens in the industry. In most cases, if you're an agent, you write the policy and you have to explain to the client the insurance. You represent insurance companies, not yourself. You're licensed as an agent, but you represent an insurance company because that's who you sell their insurance for. You will come out better getting a cancellation notice, because when you get the cancellation notice, everybody pays attention because it said cancellation, and your insurance is canceled. When you're dealing with property insurance, I don't know how many have heard it, but we call it redlining. When a community, by zip code, the property values go down, insurance companies decide that they will not insure things in those communities. The way they do it, they base it based on premium. In other words, if the house or the home is worth $100,000, then they will take the risk and you can write the insurance. If it's less than $100,000, then they won't take it. So sometimes you have to end up on a non-standard market just to write an HO3 on the homeowners. The reason I say it's a bad deal because now they can write insurance and send you a policy with a reduction. And I'm telling you, most folks do not read the policy. They don't know they got a deduction or not, a reduction in what the amount of their automobile insurance or their homeowners is. So you would come out better sending them a cancellation notice because when it says cancellation, it's at the very top. And when it says that, then they will get in and get involved and call their agent or pick up the phone and call the insurance company. But if you basically just send it with a reduction, they're not going to pay any attention to it. They're just going to send the premium on to you. And then when there's a claim, they will have signed that policy and not knowing exactly what they signed. And that's the reason I said this is a bad bill. Let them send out a cancellation notice on it. Then they'll know what it is, so that will not be a mistake. I answer any questions if anybody have any for me.
No, no one has any questions.
I figured that.
You handled it beautifully. Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Is any other senator wish to speak for or against the bill? Is there objection? Agree on the report of committee which failed pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are the objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. On the passage of the bill, the yeas are 32 and the nays are 14. And this bill, having received the constitutional majority, is therefore adopted. Secretary will read House Bill 763.
House Bill 763 by Representative Nix of the 69th and others, a bill will be titled an act to amend subpart 2 of Article 16 of Chapter 2 of Title 20 of the OCGA relating to compulsory attendance for students in elementary and secondary education so as to expand the student attendance protocol committees to school climate and for other purposes. Mr. President, Senate Committee on Education Youth offers the following substitute to House Bill 763, a bill we titled an act to amend subpart 2 of Article 16 of Chapter 2 of Title 20 of the OCGA relating to compulsory attendance for students in elementary and secondary education so as to expand the student attendance protocol committees to school climate and for other purposes. Amendment 1 by Senator Ligon III and others offers the following amendment. Amend the Senate Committee substitute to House Bill 763 by striking line 90 and inserting in lieu thereof the following. Decreasing student dropouts and other negative aspects of the Amendment 2 by Senator Tater the 38th and others offers the following amendment. Amend the Senate Committee on Education and Youth substitute to House Bill 763 by striking the quotation mark at the end of line 165 and by inserting after line 165 the following. See, every public school shall conduct drills with students, teachers, and other school personnel on the execution of school safety plans in such form and at such intervals based upon guidance from the Georgia Emergency Management and Homeland Security Agency. Mr. President, that concludes the order.
Chair recognizes Senator from the 28th to present the bill. Senator from the 40th, you approach. 40th.
Thank you, Mr. President. Members of the Senate, the school shooting in Florida is a good little reminder that we've got to improve our school climate. School climate simply is going to deal with the mental health needs of our children, and I think logic will dictate that as that reduces the likelihood of shootings, and we can help promote safety and healing, and we can do that with this bill. The bill simply does a couple of things. First part, dealing with school climate. We already have a committee set forth by the Superior Court of each county. That committee is charged with dealing with attendance policies. This simply adds in school climate to that committee. And the second part, we added in committee in our Education and Youth Committee will simply deal with the school safety. With that, Mr. President, I'll yield for questions.
No questions, Senator. Chair recognizes Senator from the 3rd speak to Amendment 1.
Thank you, Mr. President. The effect of Amendment 1 is to remove the word suspensions and expulsions from line number 90. And the reason is that in the Parkland shooting, there was a focus on reducing suspension and expulsions. And as a result of that, there were 41 disciplinary incidents with that shooter. And then a couple of them could have been felonies, but they were not dealt with according to reports. And our focus should be on maintaining the discipline in the classroom and keeping an environment where students are able to learn. And I agree that if there are issues, then we need to have programs or do something for those that are causing the disruptions, move them to an alternative school. But we need to ensure that our focus is providing safe places, areas where there's discipline and an environment of learning. Mr. President, I'll yield the well unless there are any questions.
You do have questions. Chair recognizes Senator from the 40th for a question.
Senator Yield?
Yes, sir.
Senator, isn't it true that I understand that why you're eliminating these 2 words is because it also says we're trying to obviously do away with dropouts and other negative aspects of the school environment.
Correct.
However, when we do have situations where someone is really
disruptive,
bad, then we have to have them get out of there.
That's right. Sometimes you have to address the problem in order to let students who are there who want to learn.
Thank you.
Chair recognizes Senator from the 42nd for a question.
Thank you, Mr. President. Will the senator yield?
Yes.
Senator, it would seem to me that while, of course, I agree with you that there are problems, some of which you've outlined, that absolutely need to be handled, I mean, don't you also agree that a lot of the work that we've been doing in this body, in fact, I know the senator from the 18th was mentioning positive behavioral interventions and supports in the well related to some legislation just the other day, and that's legislation we've been moving forward, and that all surrounds this notion of, while acknowledging that it's not always going to be perfect, we do want to reduce suspensions and expulsions because they don't really mirror any actual goal that the state would have in educating its kids. And so it would seem that in striking those 2 words, while it's not a major change in this legislation, it would seem that we would be expressing the will that we don't really want to reduce expulsions and suspensions.
I think that we want to promote discipline and education in our classrooms, and if you have situations where a child is just not responding and it continues to disrupt and does not cooperate, then you have to take some kind of action. And sometimes you have to
Well,
suspend
Senator,
that child.
if you'd further yield, of course, that is going to be the case
Right.
in certain instances. But would you also agree that what we've been talking about nationally as well as in this state for the last number of years is that the suspensions and expulsions are too high. They're not meted out fairly. They're not productive to the goal of educating our kids, and both things can be true. What you're saying about needing to take care of discipline problems can be true, but at the same time, we still need to be concerned about suspending and expulsing kids when all that's going to do is, in some instances, further isolate them and back them away from the goal of being able to get a high school diploma and become productive members of society.
And so if that's your focus, then what you're doing is you're putting those that are in the classroom that want to learn, they have to sit there and go through the continued disruptions and are not learning. One of the complaints that I hear from teachers is that they can't keep order in the classroom. And so I think that if we focus on the order and the discipline, and you're right, and maintaining a good climate, a climate of learning in the school, and then you maybe address these in other ways, then I think that we'll accomplish the goal. Once the word gets out that, hey, you know what, if you're disruptive in the classroom and you're not learning, then maybe that will begin to change some behavior. But I think that we're all I'm saying is that the focus is being misplaced a little bit by including these words in these reports, just as it was in Parkland. The focus was misplaced. The focus was such that it was excusing this conduct. There were 41 incidents in that school that weren't addressed. Some of them were serious. They weren't addressed. They weren't reported. He was not expelled timely. Yes, he was expelled.
He was expelled, yeah.
He was expelled, but not in a timely manner. This went on for way too long. And so we need to just shift our focus here.
But Senator, I don't really know that if anything, his expulsion, and this is anecdotal in one situation, so probably discussing it isn't that useful, but you could argue that his expulsion hastened the situation that ended up occurring. I guess my question is, are you saying that we should be focusing on discipline and we should not be focusing at all on trying to reduce suspensions and expulsions?
I think that focusing on discipline will help that problem. And then there can be other options available for those students that are not able to stay in a traditional classroom. So,
Chair recognizes Senator from the 12th for a question.
Thank you, Mr. President. Senator,
yes.
Would you yield for a few questions?
Yes, ma'am.
Is it not true that in our schools today there are counselors? There are supposedly trained individuals in the classroom as well as leaders in the school that have many options to help with those students that have disciplinary problems?
I'm sure that there are. I'm sure that.
So is it true that what I'm understanding is, are you saying that it's okay for us to continuously expel? And expel means long periods of time away from the school,
right.
Out of school, without getting any kind of educational services
right.
for those individuals that are extremely young. Would you also say that sometimes it's not necessarily the fault of the child, but the kind of training that has been received by the classroom teacher or the administrator in the building?
I think that there are a lot of different circumstances, but I think that I don't think that children are expelled for no reason at all. I think that they're frequently there are issues.
You are absolutely correct.
They're not.
But we are the adults
right.
in that classroom, in that community, and in that, as head of that building. And we set the tone, we set the climate. And if you sit by and allow a third grader or a kindergartner to take over your classroom, then there's probably the wrong kind of training that you've had as a classroom teacher. If it becomes an epidemic in your classroom, then there are means that are provided to help that child, and that's what we are there for.
Right.
Am I correct?
I agree. I mean,
Yes,
I think
sir.
that it's important to keep a good climate in the
Yes, sir.
classroom. But I think that when you start saying, okay, our main focus is we're shifting it, that we're just going to keep a child in if there's disruption and
No.
And then I think that that's misplaced.
It is, and I agree with you totally, because there are teachers that spend a lot of time correcting the discipline that's going on in the classroom. But
Right.
there remains a problem with the kind of disciplinary training that teacher has
think that-
had. And he or she will seek some kind of training or some kind of assistance from the principal of that building.
I believe that what you're expressing is also expressed in the remainder of the bill when it talks about a climate and reducing dropouts and other concerns, and also the fact, just like you mentioned, that there are counselors there that are able to work with the children as they have
Sure.
needs. And certainly I'm not saying that we shouldn't do that. I think that we should. But I believe that, you know, I wanted to shift the focus some away from just.
But putting these children on the street is certainly not the right answer. I appreciate you.
Right,
Thank you.
Thank you.
No further questions, Senator. Chair
Yield
now
well.
recognizes Senator from the 38th present her amendment, amendment number 2.
Thank you, Mr. President. Colleagues, Amendment number 2 is language that we passed out of the Senate several weeks ago. It went over to the House, and in the wisdom or lack of wisdom, I'm not trying to knock anybody, they changed the language, and that became, and passed it out of committee, but that became disagreeable to it offended and was disagreeable to many members of the House. So unfortunately, it was not able to get through rules as a result of that. And so all this is doing is taking the language back to what I originally had in the bill, which was agreeable to this particular body. So I ask your favorable consideration and vote on this amendment.
Thank you, Senator. No
Thank you.
questions. Question now is on amendment number 1, authored by the senator from the 3rd. Is there objection? Is there objection to amendment number 1? There is objection by the senator from the 28th. All of those in favor of amendment 1, authored by the senator from the 3rd, rise, stand, and be counted. Reverse. On amendment number 1, the yeas are 12, the nays are 23, and amendment number 1 has lost. Is there now objection to amendment number 2? Without objection, amendment number 2 will now be adopted. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection agreed on the report of committee which failed to pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put in? Objection. Chairs none. Main question is ordered. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 0, and this bill, MC Rex constitutional majority, is therefore adopted. I would like to direct the Senate's attention to Zoe, Sarah, Kaylee, Molly, and Nathan in the back for being here with us all this time. The last pages, we appreciate you guys very, very much. Only time you get to walk down the center aisle till you get married. Thank you all very much. Appreciate your hard work today. Secretary will read House Bill 782.
House Bill 782 by Representative Rhodes of the 120th and others. A bill will be titled Enactment Code Section 161360 of the OCJ relating to privacy and confidentiality, use of data and security program for the prescription drug monitoring program database and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute to House Bill 782. A bill will be titled Enactment Code Section 161360 of the OCJ relating to privacy and confidentiality, use of data and secure program for the prescription drug monitoring program database and for other purposes. Mr. President, Amendment 1 by Senator Watson the first offers the following amendment. Amend the substitute to House Bill 782 by striking or at the end of line 146, by replacing the period at the end of line 164 with or, and by adding between lines 164 and 165 the following payments by an immediate care home and for other purposes. Mr. President, that concludes the order.
Chair recognizes we have an amendment. We have a late arriving amendment. Secretary will read.
Amendment 2 by Senator Williams the 27th and others offers the following amendment. Amend the Senate substitute to House Bill 782 by adding after duties on line 9 the following to amend Code Section 312A18 of the OCJ relating to establishment of the low THC oil patient registry, definitions, purpose, registration cards, semi-annual reports, and waiver forms, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 20th present the bill.
Thank you, Mr. President. House Bill 782 is an agency bill. It's intended to streamline and improve the effectiveness of the prescription drug monitoring program. I'm going to talk to Section 1 of the bill, and then I'll let our esteemed Health and Human Services chair ladies speak to the rest of the bill. It allows the Department of Public Health to share data in the PDMP program with other states and with law enforcement if there's a subpoena. Allows the department to share data with electronic health records, so providers will be able to log into their electronic health record system and view the prescription information for their patient. Finally, it cleans up language to simplify the registration process for delegates so that you do not have to register twice. If there are any questions on that part, I'll be happy to answer them. If not, I will yield the well.
No questions. Questions on the adoption of the, oh, I'm sorry, excuse me. We do have an amendment. Chair recognizes the senator from, we have two amendments. Chair's going to recognize senator from the first, senator from the first. Senator from the first, you want to speak to your amendment? No? All right. Chair recognizes senator from
27.
Is that amendment number 2? Chair recognizes senator from 27th to speak to amendment number 2.
Thank you, Mr. President. There is no doubt that we have an opioid crisis among us. And one of the things that I have heard as I've traveled this great state are the stories about how people that are on 30 and 40 and 50 prescription drugs are able to come off of the vast majority of those with the aid of cannabidiol oil. And today, this Senate body, we've already denied thousands of Georgians the ability to access this oil. We've made it harder for them to take care of their health. This bill allows our veterans, those suffering from PTSD, to get access to this oil so they can live a better, safer life. My father, who suffered from PTSD having served in Vietnam, committed suicide when I was 14 years old. I missed my father seeing me graduate from high school, graduating from college, getting married, the birth of my first, second, third, and fourth child. If this oil can help those people of Georgia spend more time with their loved ones, spend more quality time with those that have served our country, they not deserve the right to have that. This bill gives them that right so they can access this cannabidiol oil so that they can not have to take all these opioids, all these prescription drugs, and live a healthy life. With that, Mr. President, I yield the well.
Chair recognizes Senator from the 45th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
At the proper time, I'd like to ask for a ruling of germaneness on amendment number 2 at the proper time. If you'd
All right.
let me
Do
know.
you wish to speak to the bill, though?
Yes, I do.
You're recognized to do so at this time.
Thank you, ladies and gentlemen of the Senate. I know the time is of the essence. I also know that House Bill 782 is very important. The first part of the bill, as described by the senator from the 20th, is part of the governor's initiative to reforming the PDMP, and it's very important. The second part is a bill that we've already addressed, Senate Bill 352. This particular bill is the opioid reformation bill, and it addresses the issues of patient brokering, substance abuse, and the opioid crisis and insurance fraud. We've already passed this through here. I believe it was a unanimous vote in the Senate. Unfortunately, in the House, it has not had a vote, and that's why it was tacked on to this bill. I do agree with amendment number 1. That comes from a nonprofit, and we're taking care of them and making sure that they can operate. And I disagree with amendment number 2, and I will ask for germaneness on that amendment. I'll be glad to answer any questions. And if there's no questions, I yield the well.
No questions, Senator.
Thank you very much.
Hey, Renee. Okay, excuse me. The question is on amendment number 1, authored by the senator from the 1st. Senator from the 9th, what purpose you rise? Senator from the 9th is recognized. Speak to the bill.
Thank you, Mr. President. Ladies and gentlemen, this is an administration bill. And the administration is against all extra amendments that are on this bill. They are not, I would say it's safe to say, they weren't pleased about it being lit up in committee as well. So I'd ask you to vote down all amendments. Thank you very much.
Question is on amendment number 1, authored by the senator from the 1st. Is there objection? There is objection. All those in favor of amendment number 1, authored by the senator from the 1st, rise, stand, and be counted. Chair recognizes senator from the 40th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Isn't the chairman from the 45th in favor of this amendment? Answers that question.
Reverse. On amendment number 1, the yeas are 18 and the nays are 13, and the amendment has passed. Question now is on amendment number 2, authored by the senator from the 27th. All those in favor, rise, stand, and be counted. The senators moving the yeas and nays. Shall the yeas and nays be sustained? One, two, three. There's 5 that have voted. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes senator from the 27th. State your inquiry.
Does this bill not give those that are suffering from PTSD, those young, brave men and women that have served our country, the ability to access the ability to access Chemodyl oil? They have served our country. The least we can do is give them the access they desire, they need.
Chair recognizes Senator from the 45th. What purpose you rise?
Parliamentary inquiry. Is
State
it
your
not
inquiry.
true that about 5 bills ago that we addressed this particular issue? There's no need in voting on it for this one?
Senator has great passion for which she speaks. On the motion, or excuse me, on the amendment number 2, the yeas are 21 and the nays are 28, and the amendment has lost. The question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree in the report of committee which fair will pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary will unlock the machine. Senator from the 51st. Approach. On the passage of the bill, the yeas are 49, the nays are 0, and this bill, having received the constitutional majority, is therefore adopted. Chair recognizes Senator from the 21st.
Mr. President, I move that the Senate insist on its substitute to HB 930.
Read the caption.
House Bill 930 by Representative Tanner, the ninth and others, a bill will be titled and act to amend Chapter 8 of Title 36, Title 40, and Chapter 32 of Title 50 of the OC relating provisions applicable to counties, municipal corporations, and other governmental entities, revenue and taxation in the Georgia Regional Transportation Authority, and for other purposes. That concludes the order.
Is there objection? Without objection, the Senate has insisted on its substitute. Senator from the 18th, Senator from the 56th, if y'all will approach, please. All right, Chair recognizes Senator from the 51st.
Thank you, Mr. President. I move that the Senate adhere to its disagreement to House substitute to SB 402 and that a conference committee be appointed.
Senators moving for a conference committee. Secretary will read.
Senate Bill 402 by Senator Gooch to the 51st and others. A bill will be titled enact the Achieving Connectivity Everywhere Act to amend Title 32, 36, 48, and 50 of the OCGA relating to highways, privileges, and ferries, local government, revenue, and taxation, and state government, respectively, so as to provide for broadband services, planning, and for other purposes. That concludes the order.
Sorry. Is there objection? Without objection, the conferees will be the senator from the 51st, the senator from the 18th, and the senator from the 56th will be the conferees to the broadband. We have another special Ladies and gentlemen of the Senate, let me have your attention for just a moment. We have another special guest we would like to recognize. Secretary will read a resolution.
Senate Resolution 1114 by Senator Miller of 49th and others. A resolution commending John W. Long for his outstanding service to the Georgia State Senate and congratulating him on the occasion of his retirement as Sergeant at Arms and for other purposes. Whereas John W. Long presently serves this body as its Sergeant at Arms, having filled such role since 2011, whereas John served as a doorkeeper for the Senate prior to his appointment as Sergeant at Arms since at least 2006, whereas the office of Sergeant at Arms is more than a ceremonial position, requiring the holder to manage a team of doorkeepers and to enforce the rules of the Senate regarding access to the Senate chamber while being cordial and respectful to everyone with whom he comes in contact. and whereas it is only fitting and proper to recognize John on the occasion of his retirement. Now therefore be resolved by the Senate that the members of this body commend John W. Long for his years of outstanding service to the Georgia Senate and extend to him their very best wishes for health and happiness upon his retirement. That concludes the order.
Is there objection to adoption of the resolution? The chair is none, and the resolution is adopted. We have so much valued and appreciated our Sergeant at Arms, John Long. What a wonderful man he is and has been to this Senate so many years, and we're going to miss his smiling face and his cheerful attitude each and every day, but we appreciate the man he is, and it's always been a great honor for me to say Mr. Sergeant at Arms and listen to him do his introductions. Speaking of the resolution, it's my honor now to call upon the President Pro Tem of the body, Senator from the 49th.
Thank you, Mr. President. It gives me great honor and great joy to commemorate John Long on this great occasion of his employment here and his participation here in this great body. He hails from Jackson County. He's got many, many friends in that community. Every time I go to Jackson County, I bump into somebody and they say, "Do you know John Long?" He has quite a reputation in the community as a man of honor, a man of integrity, a man of dignity, a man who loves his wife and loves his family. Ladies and gentlemen of the Senate, I'd like for John to say a couple of brief words. We want to keep it brief, John. We're trying to get out of here. And then we'd like to really just love on him for just a minute. John?
Mr. Lieutenant Governor, Mr. President Pro Tem, and an individual who has been a great inspiration and given me many kindness occasions, the Honorable David Cook, Secretary of the Senate, and of course my dear senators, and last but not least, the doorkeepers that I've worked with for many years. This will be a journey which I'll never forget. I appreciate all of you very, very much. And I want to wish you and all of your families the very best in years to come. Again, I appreciate you and love all of you very much. Thank you.
And also, if I could, just have the Senate's attention, Wallace Lindsay, one of our great doorkeepers. This is his year of retirement as well. Let's say a special thank you to Wallace as well. We appreciate you. Secretary will read House Bill 790.
House Bill 790, by resolution of administration of the 104th and others. The bill will be titled an act amend Article 2 of Chapter 13 of Title 50 of the OCGA relating to the Office of State Administrative Hearings so as to implement recommendations of the Court Reform Council to improve efficiencies and achieve best practices for the administration of justice. For other purposes, Mr. President, Senate Committee on Judiciary offers the following substitute to House Bill 790. A bill will be titled an act amend Chapter 13 of Title 50 of the OCGA relating to administrative procedures so as to implement recommendations of the Court Reform Council to improve efficiencies and achieve best practices for the administration of justice and for other purposes. Mr. President, that concludes the order.
Chair recognizes, Secretary will read an amendment. We have a late arriving amendment. Guys, if y'all would, I mean, you know these bills are coming. We really would like to have the amendments so they could be printed so everyone could see them ahead of time versus putting them up on the screen.
Amendment 1 by Senator Harbin of the 16th and others offers the following amendment. Amend the Senate Committee on Judiciary Substitute to House Bill 790 by replacing lines 1 through 2 with the following to amend Title 50 of the OCJ relating to state government so as to implement recommendations of the Court Reform Council by replacing line 7 with the following. Enforce subpoena and sanction parties to correct cross-references, provide for the preservation of religious freedom, provide related and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 17th. Present the bill. Oh, he's not. Who's going to carry the bill? Do you want to move it to the foot of the calendar, or you want to present it, Senator, from the 23rd? Huh? Chair recognizes Senator from the 23rd.
House Bill 790, it comes from the Court Reform Council. This bill deals with regulatory appeals. It takes out a middle step that typically is just a rubber stamp. That is from the administrative judge to the agency head. It takes the agency head step out, so if you want to appeal the administrative ruling, you go straight to Superior Court. If there are any questions, I'll attempt to answer.
There are no questions, Senator.
Urge approval of House Bill 790.
Chair recognizes Senator from the 16th to present the amendment. Senator from the 16th wishes to defer to the senator from the 27th to speak to the amendment. We have the amendment up on the board. I know you can't see it.
Thank you, Mr. President. This is a very common amendment. It is the RFRA amendment. It is the identical language that we are currently under on the federal level. We're just making it apply to the state level. I believe we're all very familiar with this. We understand the need to protect our religious rights and liberties here in this state and to grant the state courts the same law to fall underneath as our federal. So again, it's the RFRA bill that we are going to attach this amendment. And with that, Mr. President, I yield the will.
You have some questions, Senator. Nope. Senator has yielded. Chair recognizes Senator from the 6th. What purpose you rise?
Mr. President, I'd like a germaneness ruling on this amendment.
Chair recognizes Senator from the 16th.
Yes, sir. I wish to withdraw the amendment to this bill, please, sir.
Senator is the lead author. Is there objection? Senator from the 27th objects. All those in favor of the motion to, hold on a second. All those in favor of the motion to withdraw, there is objection on it. All those in favor, the yeas and nays, shall the yeas and nays be sustained? There's 1, 2. There are 3 hands that I see. The yeas and nays. Unfortunately, that doesn't work. 3 hands. It does take 5. So the motion for yeas and nays have failed. All those in favor of allowing the senator from the 16th, the lead sponsor of the amendment, to withdraw it, rise, stand, and be counted. Reverse. On the motion, the ayes are 36, the nays are 3, and the amendment has been withdrawn. Now the question on the adoption of the committee substitute is the objection. Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreeing to Porter Committee which failed pass the bill. Chairs none. Porter Committee is agreed to. All those in favor of the bill, vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 48, the nays are 1, and this bill, MC Rex constitutional majority, is therefore adopted. Chair recognizes Senator from the 21st. 21st.
Mr. President, I move that the Senate adhere to its substitute to HB 930 and that a conference committee be appointed.
Read the caption.
House Bill 930 by Representative Tanner of the 9th and others, a bill we title enactment in Chapter 80 of Title 36, Title 48, and Chapter 32 of Title 50 of the OCGA relating to provisions applicable to counties, municipal corporations, and other governmental entities, revenue and taxation, and the Georgia Regional Transportation Authority, and for other purposes. That concludes the order.
Is there objection? Without objection, the conferees to House Bill 930 will be the senator from the 21st, the senator from the 51st, and the senator from the 26th. 26th. We have some first readers we would like to go ahead and take care of. Secretary will read.
Mr. President, the House has passed by the requisite constitutional the following bills of the House and Senate. House Bill 1061 by Representative Morris, the 156, a bill we titled an act to provide a new charter for the town of Terrytown, to provide for incorporation, boundaries, and powers of the city, to provide for a governing authority of such city and powers, duties, authority, election, terms, method of filling vacancies, compensation, qualifications, prohibitions, removed from office. House Bill 1063 by Representative Bruce of the 61st and others, a bill we titled an act.
Slow go.
House Bill 1064 by Representative Martin, then a 49.
Slow go.
House Bill 1065 by Representative Benton, the 31st and others, a bill
Slow go.
House Bill 1067 by Representative
Slow go.
House Bill 1068 by Representative
Slow
Jones.
go.
House Bill 1069 by Representative Jones of the 91st and others.
Slow go.
House Bill 1070 by Representative Jones of the 91st and others.
Slow go.
House Bill 1071 by Representative Jones.
Slow go.
House Bill 1072 by Representative
Slow go.
Senate Bill 477 by Senator Parent of the 42nd.
Slow go.
Mr. President, that concludes the order.
Would like to, do you have the resolution? Let me have the Senate's attention just for a moment. We're getting ready to go ahead and adjourn, but before we do have a resolution that every single member of this body has signed for the Honorable Zell Miller, and we would like to read and adopt that before we conclude our business of the day. Secretary will read.
Senate Resolution 1131 by Senators Miller of the 49th and others. A resolution honoring and remembering the life of the Honorable Zell Bryan Miller, former Lieutenant Governor, Governor, and United States Senator of this great state. Whereas the Honorable Zell Bryan Miller was born on February 24, 1932 in Young Harris, Georgia, to Stephen Grady Miller and Bertie Miller. And whereas he attended Young Harris College and later earned a bachelor's and master's degree from the University of Georgia. Whereas he served his country with honor and distinction in the United States Marine Corps from 1953 to 1956. Whereas during a 40-year career of public service, he has served the state of Georgia as mayor, state senator, lieutenant governor, governor, and United States senator. And whereas he was elected in 1990 to serve as governor, where he served the United States Senator from 2000 to 2004. And whereas in 2008, Zell B. Miller Learning Center at the University of Georgia was dedicated in his honor, and in 2014, the Zell and Shirley Miller Library at Young Harris College was dedicated. And whereas on the morning of March 23, 2018, he died peaceably at his home in Young Harris, surrounded by his beloved wife Shirley and his family. And whereas the state of Georgia mourns the loss of this monumental statesman and distinguished Georgian, now therefore be it resolved by the Senate that the members of this body join together to express their deepest regret at the passing of former Lieutenant Governor, United States Senator Zell Bryan Miller, and extend their most sincere condolences to his family. Mr. President, that completes the order.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. we will give all the Senate members the details of the arrangement. I think the plan at this point is that the governor will be laying in state here on Wednesday. Chair recognizes the majority leader.
Thank you, Mr. President. I move the Senate stand adjourned until 10 o'clock a.m. on Tuesday, March 27, 2018, the year of our Lord.
Read the announcements.
Rules will meet at 10 a.m. Monday morning at 450 at the Capitol. That concludes the order.
Chair recognizes Senator from the 53rd.
Thank you, Mr. President. Ladies and gentlemen, Senate Rules Committee will be meeting 10 a.m. Monday, and then the entire Senate members are invited for lunch after the meeting at 12 noon, and love to have everyone there. It'll be the Senate members plus the Senate Rules staff and supporting staff for the lunch, and Lieutenant Governor's office as well. The Secretary of Senate's office. But anyway, I encourage you to come Monday, and those who would like to be in attendance, love to have you attend. Thank you, Mr. President.
Thank you, Senator. Any other announcements? The majority leaders move Senate stand adjourned until 10 a.m. Tuesday, March the 27th. All those in favor will say aye. All those opposed, no. Oh, my. The ayes clearly have it. We stand adjourned.